Hey guys, welcome back to True Crime with Shannon, where I cover missing persons, unsolved cases, crime news, and more. Well, we had a big news update in the Idaho 4 case. We learned this morning, actually, the first place I learned it was from Ashley Banfield from News Nation's Twitter post, that she posted that a grand jury has indicted BRYAN KOHBERGER. And this has been confirmed. It was an indictment. It was filed on Tuesday in the 2nd District Court in the Lata County Grand Jury. It accuses BRYAN KOHBERGER of 4 counts of first-degree murder and 1 count of burglary. And under Idaho law, burglary is defined as entering a house, room, apartment, business, or any other type of building or vehicle with intent to commit a felony. The indictment is not a pronouncement of guilt. It is, however, a statement of charges, and KOHBERGER still has the right to a trial by jury. KOHBERGER is expected to answer these charges when he appears for arraignment in Lata County District Court next Monday, which is May 22nd at 9 a.m., 10 a.m. Pacific time, and then apparently the judge is Judge John Judge, which I found interesting. Judge is presiding over the case. A preliminary hearing previously scheduled to take place is canceled, so that June 26th date that we have all been waiting for is canceled now because of the grand jury indictment. Now I'm going to play a bit from News Nation. They had an attorney speaking a bit about this update in the case, but I wanted to just quickly go over. There was a redacted version of the indictment posted this morning, and it's only about 2.5 pages, not even. Super short. It lists count 1 as burglary. This alleges that KOHBERGER unlawfully entered the house at 1122 King Road in Moscow with the intent to commit the felony crime of murder. Count 2 is murder in the first degree. This alleges that KOHBERGER willfully, unlawfully, with premeditation, and with malice aforethought killed and murdered Madison Mogen by stabbing. Count 3 is murder in the first degree, using similar language to count 2. This one alleges that KOHBERGER murdered Santa Cardoodle. And count 4 is murder in the first degree, also using similar language, and it alleges that KOHBERGER murdered Ethan Chapin. The last sentence of the indictment just refers to the allegations as being, quote, contrary to the form, force, and effect of the statutes in such a case made and provided, and against the peace and dignity of the state of Idaho. Now, the names of all the witnesses examined by the grand jury in the KOHBERGER case are sealed. The Lata County prosecutor, Bill Thompson, has explained why he believes the name should be sealed in the motion, which the judge granted. In that motion, Thompson wrote that the prospective witnesses or their families and associates had already complained of being harassed in person and on social media, and he argued that releasing their names would make their situation worse and undermine the integrity of the case. Because sadly, this is such a huge case that a lot of folks, and we're not just talking about the mainstream media, we're talking YouTubers, social media, all over the place, have sadly harassed some of these witnesses and families, and it's just not okay. So at this point, that's kind of where we are on that. But I wanted to real quickly play. There was a bit of a Q&A earlier today with an attorney that News Nation had on, and I'm just going to play a bit of it and then include the link if you would like to watch it in its entirety. So let's check it out.
So I think we could first go to the latest, which is the indictment. So BRYAN KOHBERGER was initially charged by complaint for the brutal murders of these 4 Idaho students. He's been charged in Latah County, and there's also a burglary charge, which is the least of his worries, but it's really insurance for the prosecution. And I kept saying, why did the prosecution not move forward to the grand jury indictment? Because it's really, this case is prime for indictment. It has been. The idea is that when you have a highly circumstantial case with some questionable evidence, The DNA has been questionable. The cell tower pinging with the triangulation issues has been questionable. There's been a lot of sort of dots to connect. And this is a case that's perfect for grand jury indictment, because the idea is that the prosecution does not want the defense to have the opportunity to poke holes in its case and witness testimony that comes up in a preliminary hearing. So again, a preliminary hearing is to establish probable cause that a defendant there's enough probable cause for the defendant to stand trial, essentially. And at that preliminary hearing, which was initially scheduled for June 26th, we would then hear from the defense. We wouldn't hear because there's a gag order, but the defense would essentially participate in that. They could bring their own witnesses to impeach prosecution witnesses or refute their case. They would also heavily challenge and cross-examine all of the evidence that the prosecution would put on. Well, with a grand jury, it's very different. It's a secret proceeding. BRYAN KOHBERGER does not get notice that it's happening. He gets notice afterwards that he's been indicted, and he can go pick up his transcript, right? That's what happens in all my grand jury cases. And so there's zero participation by the defense. But what's really important, and what I've seen all over Twitter this morning, is about this idea of exculpatory evidence, right? Exculpatory evidence must be presented to a grand jury. So even though this is a very sort of one-sided proceeding where you only have the prosecutor, the judge, the 12 jurors, the grand jurors, in the room with a court reporter, right? You have to still represent the evidence that is perhaps favorable to the defense, that might be, exculpatory to them. You can't just go in there with all the receipts and the incriminating evidence. And so this is a very interesting timing, because there has been a lot of back and forth about discovery outstanding to the defense, and this idea that the defense is pounding the table saying, there's exculpatory evidence that you owe us that you have not given us. Where is it? And so I think the prosecution went ahead with this grand jury ahead of the preliminary hearing now, so that, in case there's any leaks or anything, that the grand jury would be the first to essentially hear all of this evidence. So again, very interesting timing. And I'm wondering what your questions are about the indictment. So I'm going to put my glasses on because I can't see that good from this distance. But Matthew is asking, have we confirmed that the trial will be televised? We have not. So right now, there is a gag order in place, and I would imagine that this court wants to keep everything sort of really tight to the chest, and that the trial would not be televised, which of course just doesn't make it fun for the rest of us, right? We want to really hear what's happening. We just saw with Vallow, the trial was not televised, and we had to rely on great reporting, but still reporting and not really sort of seeing it for ourselves. And we don't know if that's going to be the case in Idaho. I just want to briefly address the gag order issues, because it goes to Matthew's question. So, on February 6th, there was a coalition of media that filed a writ with the Idaho Supreme Court saying the gag order should be lifted. The media, the public has an interest in the, incredible newsworthiness of the story. February 27th, the magistrate, the level at which Kohberger's case is now, magistrate court, delayed Gonsalves. That's one of the victims. The Gonsalves family had filed a motion pending the Supreme Court decision, essentially wanting this gag order modified so they could go give interviews, like on News Nation, for example. And so the magistrate delayed that because it sort of related to the same issue that the media raised in the Supreme Court. And then on April 24th, the Supreme Court said that everybody needs to first seek relief in the magistrate, the lower court, before we can issue a writ. Essentially what was being asked of the Supreme Court was a writ of mandate, lifting the gag order. So essentially that's sort of the procedural issue. And then on April 28th, the magistrate court set the Gonsalves motion for May 25th. And then on May 2nd, the media coalition came in and filed with the magistrate court as directed by the Supreme Court. And then on May 4th, the magistrate vacated that May 25th hearing and instead set it for a scheduling conference. So that's where we're at essentially now. And once this hearing gets set, at the hearing, We'll see whether this gag order is modified as to the Gonsalveses, whether it's modified or lifted altogether. The defense, of course, probably wants this in place. But I have to say this from my perspective as a defense attorney. Gag orders tend to benefit the prosecution. And that is because usually the leaks that occur are spun and disseminated in favor of the prosecution. And what that does to the defense is essentially the defense is bound by the gag order. They can't defend against those leaks, but yet those leaks happen. So it's interesting because there's been so much going on about this case that is rumor, that is not fact. And then there's analysis of the rumor. And so the gag order is very telling, I think, as to also whether this trial would be televised down the line.
So I'm going to include the link, obviously, to this article and to the video on YouTube that you can watch it. Her answering, of course, about the indictment is key. It lets us all know to explain what the differences are, why an attorney state would use a grand jury, and how BRYAN KOHBERGER had no idea this was going on, and he was probably just as surprised as the rest of us, but I'm sure he heard about it before we did this morning. And also the first question that was asked about the gag order, well, about being televised, and then she led into the gag order. So that's definitely coming up soon about that update. But this is very, very interesting. And while I was really kind of looking forward to hearing what was going to happen in June 26th and all that sort of stuff when they do the pretrial, if they weren't going to air it, it would kind of, not be a whole big situation on that. However, I'm hoping that they'll not have a gag order on all this. And more so, I hope that once this trial does get underway, that we do get it televised. It is quite a big case, a story, and get justice for these college kids. So we shall see what happens with the gag order, I guess, soon, and see if we hear anything on that one. And of course, I'm sure we'll hear more about it being televised in the near future as well. So let me know what you think in the comments. When did you first hear about it today? Did you see the Twitter post from Ashley Banfield, or did you just see it on your headlines this morning on Google or Yahoo or what have you? Let me know what you think. And with that said and done, that's all I've got for this one. And I hope you guys have a great rest of the day. Most of all, stay safe.